Okay, I think that's the last batch is coming in, and we'll start on time. Okay, thanks for coming to our Scholarly Communication seminars. I am Becky Lee from the library. I am responsible for resource management and scholarly communications. So today we are very glad to have Professor Raymond Leung to give us a talk about how to resolve disputes in the workspace through mediation. Professor Leung is an experienced mediator. He is the founding president and governor of Hong Kong Mediation Center. He is the editor of many books about mediation. For example, Asian Mediation Handbook, Hong Kong Mediation Handbook, and Chinese books include 調解技巧, 調解功架. Okay. He has also other publications about arbitration. And Professor Leung also a qualified engineer. He has a master's degree in construction management and a PhD in information engineering. He is the inventor of 2 patent trademarks in optical PCB. I'm sure you all know what is optical PCB. Okay. Currently, Professor Leung is a joint professor in civil engineering of our HKUST. So he is teaching a course on dispute resolution for engineering. Dispute resolution in engineering. Okay. Today, to me, mediation is very new topic. So we all should learn a lot after attending this seminar. So we will have a Q&A section at the end. So by now, let's welcome Professor Raymond Leung.
Okay. Can everybody hear me at the back? Especially the ones at the back. Okay. Well, actually, there are seats in front. If you want, you can move up. You know. Usually, I ask questions. When I ask questions, I pick the ones at the back. So, anyway, mediation is. I'm trying to compress a course of 40 hours into 1.5 hours, right? 1 hour, more or less. Okay. So I'll try my best to see what I can do. First of all, how many of you are graduate students? Just put up your hands. So majority, good, excellent. Okay, I'm glad. Anybody took my course before? if so, then you don't have to listen to this class. Anyway, okay. Anybody involved in mediation or know anything about mediation? If you know anything about it, put up your hands. So I really have to start from scratch. Okay. Okay. So I think that was a very excellent introduction. So here it is. But anyway, I think Becky has said it all. Actually, I'm also an arbitrator in about 16 arbitration commissions, and I totally published 6 books altogether. And I'm working on my 7th, which is on youth. And I hope that all my books should be in the library. If not, then Becky should be responsible. Okay, what I'm going to cover basically is that what is mediations and how does it apply? What form of mediation? It turns out there are different forms of mediations, which I will very briefly describe. And then what are the stages that a mediator do in mediations, and some of the quality of a mediators. Many people want to be mediators, but actually there are very few good mediators, I can say. And as far as parties is concerned, it is important that you select the right mediators, because if you don't, then you're really in trouble. Okay, I'll give you an example in due course. And because the topic that Becky wants me to cover just a little bit on arbitration, so I will have 1 slide on arbitration, so you know the difference between mediation and arbitration. I'll be happy to answer any questions during the course. If you don't understand anything, just put up your hands and I'll stop and I'll ask you to ask the questions. If not, you can always ask at the end of the class. So I just want to give you a little bit of background of mediations. Mediations started in Hong Kong around 1980s. Because actually started with construction projects. A group of us from the HAIE, Hong Kong Institute of Engineers, we were promoting mediations, and we want the government to put the mediation clause in the projects. The reason is that, as you know, and you probably heard in recent news, that practically every project that I dealt with, or the governments, or anybody that dealt with, will have disputes. Okay, and I'll explain what is dispute and what is conflict in a minute. Subsequently, finally, in the airport project, that's the airport that you're landing on right now, they finally put up a compulsory mediation clause. So a group of us went to learn about mediation, and we invite a professor from Australia to come to Hong Kong, the court group, and we learn about mediations. And we start to promote mediation in '99. I'm the founding president of the Hong Kong Mediation Center, and subsequently, finally, in 2007, that the chief executive, Donald Tsang, was mentioned in his policy address that we should have an alternative dispute resolutions. One of the reasons that I noticed why the government promote this, and I think this happens everywhere in the world, in the States, in India, in Australia, everybody is promoting ADR, alternative dispute resolution. The reason is that if you notice that regardless where you are, the court is being overloaded. Okay, you can't train enough judges to handle the disputes around town. Okay, regardless your disputes is in China, in Hong Kong, or anywhere else. So the judiciary have no choice but to think of other means of resolutions. Okay, so ADR, that's how it comes about, and suddenly they discover that mediation, it seems to be a very good form of dispute resolution, and therefore they begin to promote mediations. And finally, in 2009, January 1st, actually it started in 2008, it was announced that in Hong Kong, practically all civil litigations you need to resolve through mediation before you go to court, literally. Why is that practically? It's because this process is voluntary. That means that parties can decide to go to mediation or not go to mediations. So it's voluntary, so nobody can force you to do mediations, even today, okay? But the court is very smart. They issue a practice direction 31, which says that any parties want to go to court in civil law, under civil law, the lawyer have to explain to the party what is mediation. So first of all, you have to learn what is mediation. And second of all, you have to sign something called a mediation certificate. So that is a certificate that you committed yourself that you will intend to go to mediation. If you don't go to mediation, you have to give a very good reason. So if you don't have a very good reason, then the judge can penalize you at the time of calculating costs. So that means that when they call it cost sanctions to your case. That means that even if you win the case, normally when you win the case, the losing party will pay most of your costs, that is legal costs, etc. So if you have a dispute of $2 million, your legal costs could be $2 million, and that means that, but the court may not award you with a total $2 million of legal costs. So probably 70 to 80%. Okay, at least you will recover most of your cost of litigations, and that is quite substantial. Sometimes it goes into millions of dollars. So the judge will look at the mediator certificates and say that you did not have a good reason not to go to mediations. Okay, in that case, then you will be cost sanctioned by the court, even if you win the case. So it is a turning point in Hong Kong that the government and the judiciary is really pushing for mediation. So we come to the issues about what is mediation. I still haven't talked about what is mediations. Okay, I'll leave it to the end. But mediation, what's the difference? When you have a dispute, what do you do? What do you do normally when you have a dispute?
Try to work it out.
You try to work it out with the other side, yeah. Right? What's that called normally? You all do that every day. What's that called?
Negotiate.
Exactly. So when you have a dispute, normally what you do is that you try to negotiate with the other side and try to come up with a solution. So normally is that when you can't come into agreement with the other side, then there is a conflict. Okay. When you have a conflict with somebody, here I have some cartoons. Okay, it could be because of monetary reason. You could be just arguing with your wife or your boyfriend or your girlfriend, right? You have a conflict, okay? And then even which channel that you're watching in TV, there's the conflicts. But it doesn't really escalate into something else called disputes, okay? What is dispute? Normally is that you could have a disagreement between parties or for various reasons, because of kids, because of work. We have to come back to work, okay? Work disputes, or just a disagreement. And that is normally what we call a conflict. However, when a conflict occurs, it escalates. As time goes on, if you have a dispute and you try to resolve it through negotiation and you can resolve it right away, then the conflict disappears. But how about when the conflict lasts for a long time? Okay, such as in commercial contracts, in people bear grudges against each other. Then at the end, it escalates exponentially to become a dispute. Okay, disputes is generally something that you will have certain trying to get certain recourse as a result of conflicts. Okay, in conflicts you might have different concepts, different ideas, or even just different opinions. Okay, so what are some of the disputes in work disputes? I have to come back to the topic, the work dispute. What are some of the work disputes that you could think of? What do you think?
Promotions.
Sorry?
Promotions.
Okay, staff and university, for example. Okay, what else? What else? Somebody at the back. You said at the back. Black T-shirt. Yes.
Maybe you have different idea of a project.
Different project, that could be a conflict. That may not be a dispute, because dispute generally you have a recourse. You want to get something as a result of that. So I'm talking about what are some of the disputes in workplace. Different ideas in project, yes, okay. Obvious, very obvious. How about a senior staff and a junior staff, right? A supervisor and a staff, okay? That is quite common. Even within the university, you could have disputes with the marking system with the professor. You could have disputes between professors and the universities. Okay, could be because of promotion or wages or whatever. Okay, there's many issues occur in daily life. That is conflict will evolve into disputes. Okay. Conflict will lead to disputes. Okay, we talk about disagreement in different issues. Okay, and that's more related to social science. But disputes are you are claiming something. In commercial contracts, in trading disputes, there's a lot of these, and lead to real actions. That could be legal actions or whatever. Dispute quite often is very emotional. People tend to take positioning. For example, I want to do this. and you want to do it another way, different opinions, okay? You want to do it an opinion. It's very positioning. And what we call is adversary positions, okay? And lawyers, any lawyers here? I guess not in UST. Lawyers tend to take a very adversary position because when you go to a lawyer, well, first of all, I have to declare I'm not a lawyer, so I can say whatever about lawyers, okay? First of all, lawyers tend to take a very adversary position. The reason is that you went to him for advice, so he's trying to protect your image, your position, your positions. And he's trying to fight for your position. So it must be an adversary position. So if it's a win-lose situation at the end of the day, okay? It is the training. Just to give you some information, people train as an arbitrator. It turns out that the failure rates for lawyer taking the course are a lot higher than any other professions, okay? Because they're trained to be in adversary position, and when they're in court, they're in adversary positions. So positioning is very important. And quite often, dispute arise because of face, okay? People are angry. There's emotional outburst of people. A lot of people take somebody else to court is because they want to save face, okay? So face is very important, not only in the Chinese culture. It turns out that in every culture, it is the same thing, okay? And people will argue for the sake of arguing because they believe in their own positioning. So we talk about disputes, and now we talk about how we want to resolve it. Naturally, there are different forms of alternative dispute resolution. Mediation is one form. Other forms such as adjudications, expert determinations, naturally going to court. There are different forms of dispute resolution, but mediation is something that I think is most one of the key things about mediation is that it maintains relationship. I'll explain what is mediation to you. First of all, mediation is a flexible system. I don't call it compulsory because it's not. Because when two parties do not agree to come to mediation, no mediation can take place. So it must have consent of both parties to begin a mediation process. Okay, so consent of the parties. And what you do is that you find a neutral person, a neutral, impartial person. Neutral and impartial does not mean that you don't know the person. You know the person, but the key thing is that the outcome of the mediation, that person does not have a conflict of interest or does not benefit as a result of the mediations. So it's an impartial third party. When you go to court, you have a judge. He is also an impartial third party. Okay, but you don't select your judge, but you do select your mediators. You can appoint anyone. At the present days, the law is that you can appoint anyone to be a mediators. Okay, and I'll come to explain. Even in school, that there are school mediations. There are what they call peer mediation. Peer mediation actually are among peers, students among students. You might get a senior. A fourth-year student to try to mediate for a second-year students' disputes. Okay, that's called peer mediations. Okay, so you can appoint anybody. It is parties' determination. That is very important. In none of the other alternative dispute methods is parties' determinations. Why I say that? If you go to court, who rules? Who gave you a ruling? Who gave you a ruling? The judge. You don't select the judge, right? Actually, you have no say in the whole process. The party is only a witness in the whole process. You give your evidence in court, or you have a good lawyer present the case, and the judge will listen to what the party say, or his representative, i.e. the lawyer. Then he hear both sides with the necessary cross-examination under our common law system in Hong Kong. Then he hear everything, and based on what he hear, i.e. the evidence, he make a ruling, regardless you like it or not. So you do not decide the outcome of the judgment, right? Another form, arbitrations, okay? Arbitration. Who make the judge, the awards in arbitrations? Anybody?
The arbitrator?
Exactly. You have a chance to choose your arbitrator, because in arbitration you can select your arbitrators. So you can get an expert in the field, or you can get anybody that you like to be an arbitrator. Again, he hears the evidence. Parties don't decide. The arbitrators make the decision, right? In mediation, it's the only process that is party determination. That means you, as parties, have to agree before a settlement can be achieved. So that means that you can terminate the mediation if you don't like it. During the process of mediation, you don't like it, then you terminate. You have a chance to do that. But in court, in arbitrations, you can't. Once you submit the writs into the court, who decides the termination? The judge. You have no say. You can't stop the process. Even if you want to stop the process, you can't stop the process, both in arbitration and mediations. Okay? So here, the parties can stop the mediation process if you don't like it during the course of mediation. And naturally, the mediators can stop the process as well. So you are actually making decisions not only by hearing the evidence, you could be taking other consideration. For example, I did mediations. There was one case, I don't have much time today, so I only give a few examples. One of these cases was that the parties begin to write to each other. The lawyers are starting to write to each other for 9 months. And they all spent $2 million already. The case was $40 million in disputes. Okay, it's a trading case. It's a Hong Kong manufacturer. His factory is in China with a trading company and his sole British distributors. It's a trading case. So it's a defective goods disputes. Namely, his product was defective. Okay, the lawyers work up the claim to be $40 million. So that's the only thing they can do in court, is that you sue somebody for recourse, is how much you sue, basically. Okay? So before they went to the hearing, I still remember it was a Wednesday. I hear the call, and they want the mediation to be done on Thursday. So we started on Thursday. This case lasted 2.5 days. Okay, it was settled on Saturday afternoon. Okay, but at the end of the day, the dispute was, this is the biggest manufacturers in the world on this product, okay? And in the UK, this is the biggest distributors for this products, okay? They all still want to do business with each other, maintaining relationship, okay? That's very key. Second is that at the end of the day, because of this defective good, is that the defective goods, how is it going to be handled? Is it going to be shipped back to the factory for repair? And which part needs to be repaired? So that was very technical, okay? It's an electronic product. So which part needs to be repaired? And how is it going to ship back, okay? At the end of the mediations, okay, it was only involved in $2 million rather than $40 million. If you're being sued with $40 million suit, believe me, you're going to be bankrupt. I don't care how big a factory you are. Okay, nobody has $40 million cash in his bank. Any manufacturers. Okay, so the guy was preparing for bankruptcy. Okay, it didn't happen. It only cost $2 million. It's who is going to ship the goods back to the factory, and how is it going to repair, and how is it going to ship back. Another thing that was resolved, it turns out, is that how about in future, if there are defective goods, how is it going to be resolved? So finally, because this product when it gets to the consumer's hand, it could be 1 year from manufacturing because it's sold in a department store. Okay, so he has to ship the goods to the UK and then put it in the department store. So when is the warranty started? Is it ex-factory or when the consumer buy the product? And naturally, in any manufacturing process, you do have defects. So what's tolerable defects? 2%, 3%? So that needs to be an agreement. If you want to maintain the continuous relationship, you need to resolve all this dispute. So finally, this is all resolved in the mediations, okay? Over a span of 2.5 days, okay? But the lawyers have already written to each other for 9 months, okay? Finally, it was settled, and the parties were so happy. Believe me, they were happy, okay? Why I know that is that because after the mediation, they get on with their life. They're no longer involved with mine. But in 6 months' time, I saw the manufacturers in Hong Kong in one of the cocktail. And I asked him, "Are you still doing business with the UK distributors?" He said, "Yes, we were just having a drink in Wan Chai, one of the pub there." Okay, so the dispute didn't go to court. At the end of the day, it was resolved. And it's very important on parties' determination because it wasn't their lawyer saying that you shouldn't go to hearing, because the lawyers surely want to go to hearing because they will get more fees as a result of that. Okay, but at the end of the day, option generations, it was permitted. As I said, what are the options? Is it the only recourse is paying you $40 million? No, it turns out that it's how to repair the product. So options was generated throughout the mediation process. And why I say realistic solutions is how does it work? You know, how long does it take for you to repair and ship back the goods? And that was very important as well. So there was a lot of little details, and that was able to resolve through mediation. And I don't think you can resolve that in court or in arbitrations. Okay, that's just graphics. This is what we want at the end of the day in the mediations. And through internationally, the success rate of mediation is about 70%. It depends on the form of the dispute. Different disputes have different outcome. In Hong Kong, I would say in construction projects, generally the settlement is about 80 to 85%. So there are cases that is what I call failed mediations. Failed mediations. One of the cases I give you is what is failed mediation is that one of the examples I can give you was that I was involved in the case, and there's a trading dispute, and it was to my surprise, this is the fourth deal that they make with each other on the trading disputes. And it turns out that they have a dispute is that the Hong Kong supplier was saying that I've delivered the goods to the buyer. The buyer said, I never received the goods. Okay. Financially, it was through a third party to pay the Hong Kong supplier. And the Hong Kong supplier got the LC, everything. So he went to the bank and cashed it out, and he shipped the goods to the buyer. And the buyer said, I never received the goods. It is a high court case. It turns out that they want to come to mediation, and I happen to be the mediators. And during the mediations, I asked them, how do you want to settle? Okay, so the buyer was saying, okay, I'll settle if I get 70% of my money back. So I thought that is odd. Okay, imagine that you go to Fortress and buy a TV. Okay, you pay $8,000 and you never got the goods back. What do you do? What do you do? You want all your money back plus damage, right? Okay, you won't accept 70% of $8,000, so you only get $5,600 back, and you settle. That's unusual. Okay, something's wrong with this case. So I figured that, well, because in mediation, I would not know that would the party lie to me or not because you are not sworn under the oath. Okay, even if you lie, I wouldn't know. So what I decided is, because this is a high court case, it's better that he goes back to the high court. So as a mediator, it's easy. You know, if you don't settle, well, that's the end of the mediation. I declare that this is closed. Goodbye. You go back to high court. Right? That's exactly what I did. So because there was something wrong, I felt there was something illegal going on around there. So, but it's not up to me to discover the illegal activities. Right? That's up to the high court to decide. So, but anyway, that case, as far as I understand, is that before they went to court, they settled. But these are real cases, anyway. Okay, there are different forms of mediations. In Hong Kong, we promote facilitative mediations. You might not know the terms. Don't worry about the terms. I just want to let you know that there are different forms. And facilitative is generally used in commercial and workplace mediations. Is that facilitative? Is that means that the mediators will facilitate the two parties to come to a settlement. So I help you to come to a settlement, but I don't give you advice. I don't tell you what to do. I cannot, as a matter of fact, I cannot tell you what to do. Okay. There are other forms like transformative, and this is more involved in family disputes. Okay. In Hong Kong now, if you want a divorce in the court, then you have to go to family mediations before you go and see the judge. They will talk about custodies of children, alimonies, etc. And why I put empowerment is that because there are disputes, sometimes there are disputes, is that you have a very different power of interest. Okay, if you are a big developer versus a small contractors. So you use transformative mediations. Settlement, and quite often settlement is you try to settle, you want to get paid. So this is quite often in construction, building projects. Evaluative is sometimes it's mixed with facilitative. However, because there are legal liability on the evaluative mediations, that means that unless I'm an expert in the area, then I can evaluate the situation and make a recommendation to the parties, and parties, it's up to the parties to accept or not. That's evaluative. And right now in Hong Kong, in the intellectual property sectors, we're trying to use evaluative mediation. But generally, you need to be an expert in a particular field before you use evaluative mediation. Narrative is that is something here is victim-offender mediation, what we call. Just like if a young person that is stole from a store, even though he could be jailed, he could be serving sentences, even after the sentence, that young person will not dare to walk into the same shop again. So what happened is that because when the shopkeeper sees this young person, he's going to give him a help, regardless you serve sentence or not. So actually, at present, in the correctional services, we use narrative mediation on victim offender. It's try to put the victim and the offender together and try to resolve their grievances. Okay, once that is resolved, then the young person can walk back into the shop with no problem. Okay, peer mediation we talk about is in schools. Actually, in primary school now and high school, we do promote peer mediation is for more senior students mediate lower grades disputes. Any questions so far? I cover a lot, actually. Okay, applications. Okay, as I said, there are trading disputes, intellectual properties, even domain names disputes. Shareholders dispute is quite often when a big shareholder wants to buy this small shareholder at what price? How is it going to value? Okay, consumer actually there are arbitration commissions that is looking into resolving consumer dispute. When you go to a department store, if you have a dispute on the product, how is it going to be resolved that dispute. Okay, these could be talking about $200, and you don't want to hire somebody to do it. So there are organizations that is looking into internet to resolve these kind of disputes at the moment. Agency dispute and distribution rights. Quite often, certain products are awarded to a certain agency, and there are different agents sell to the same place or things like that. Construction insurance is that in travel and personal injury, quite a lot of personal injury case. Financial products, you might heard of the Lehman Brothers disputes. That's why in Hong Kong we have the Financial Dispute Resolution Center. Even in labor disputes, okay, wages you talk about. Community leak from the apartment upstairs to your flat, building management, even where to put the rubbish, land boundary not to mention. Okay, divorce, school, healthcare. Healthcare is in hospital, you hear it from the news. Quite often there are disputes between doctors and patients. In China, somebody, a doctor who recently just got chopped up. Anyway, international borders disputes. A classic case is the Camp David Accord, which is President Carter was the mediators for the Israel and the Egyptians. Okay, I'm just going to, I think. How much time I got?
Quite a lot. What was
What time
45 minutes. The end will be at 2.
Okay. So I still have some time. Okay. So it's important you select the right mediators. I'm just going to give you the whole lot. Oops. Okay. Naturally, you want somebody that is impartial, okay, non-judgmental is because he's not a judge. He's helping the parties to come into a settlement. So actually, personally, I'm an arbitrator and a mediator. So I find that it's more difficult to do mediation than arbitrations. Because in arbitration, I only listen to the two sides. Once I get all the evidence, I look at the evidence and make an award. As simple as that. But in mediations, I have to constantly talk to both sides. When I talk to one side, I'll come to the stages of mediation in a minute. There are different processes, like joint session. Joint session means that when both parties are together with the mediators, okay? So don't forget, every action that the mediator does, parties are watching. So that means that when you're talking to parties, you have to behave in certain ways. Okay, so it's very tiring that when I talk to the parties singly, okay, I have to pay special attention. I talk to the other side, I have to pay special attention, but the parties can rest when I talk to the other side. So it was a very tiring process, what I find. And well, I think being nice is important. You thought everybody's nice, and you'd be surprised. Sometimes people are not really nice, okay? So that is the reality of life. And I think as a mediator, you need a positive attitude. I was involved as an advisor to a party once. We were very disappointed at the mediator. The reason is that it was a construction case, and it turns out that we present our case, and the other side present our case at 4 o'clock. Suddenly, the mediator said, I don't think I can handle the case, therefore I declare this mediation finished. And both sides were shocked, because we haven't even finished presenting our positioning. Okay? So I think be positive is very important. You can't give up. As a mediator, you can't give up. You have to help the parties to come into a settlement. Why I say confidential is because the process itself is confidential. When I talk to one side alone, I cannot disclose my discussion with him unless I get the consensus from the parties. Okay? So that means that you establish certain trust between parties and the mediators. Okay? So the whole process is confidential, and as a matter of fact, before we start, we sign a mediators agreement. And in the mediators agreement, it said the mediators cannot be subpoenaed for future litigations or arbitrations. So everything, all the notes taking that I did, when I finished the mediation, that will be destroyed. So I become a blank person. I forgot everything, you know. So even if you subpoena me to the arbitration or the court case, I wouldn't remember anything. Sorry. So, okay, that's how we kept confidentiality within mediations. And it's important that the mediators control the process, because the only thing that he can do is, other than facilitating the parties to communicate, because parties don't communicate with each other. As I said earlier, that a lot of people, because of face, they go into litigation. Because of face, because of emotional outbursts, they go into a dispute. Okay, and as a mediator, I'm the person that controls people's emotions. You could have certain outbursts, but with limits. And there are scales that, when we learn mediation, that you can learn. I'll talk about this in a few minutes. Okay. So we have to be sensitive to feelings, because when the person is very aggravated about certain things, he cannot think logically. At the same time, it's the same thing that if you talk at the same time and I talk at the same time, you don't listen to what I say. Okay? So quite often when people argue with each other, both of you are talking, but you are not really listening to each other. When I start a mediation, quite often I ask two sides to send me a 1-page or 2-page of what is the dispute all about. And quite frequently, I find that the 2 pages that I got from both sides, they are very different. They should be the same, isn't it? If you are arguing about something, you should know what you're arguing. But in reality, people don't argue about the same thing. You could be talking about something else, and you could be talking about something else. So this is how I get them into, are you arguing about the same thing? Come on, let's look at it. You guys are not arguing the same thing. So let's get down to what is the issues at hand. Okay? Okay, so you have to prepare. So that's not only apply to mediators. If you ever get yourself into a position of mediation, you should prepare as well. Just like you go to court, you should prepare. Quite a lot of people, they just walk in, they thought that, okay, the mediator will do all the work. But no, sorry, it's the party that is doing all the work. Okay, I try to be fair, but at least what is fairness? Okay, I don't think there's any fair person around, even if you are in court. Do you think a judge is fair? Very simply. Do you think a judge is fair?
Not always.
Why?
Because it depends how he looks at the statements in the law and make the decision.
Do you think a group of jury is fair?
A group?
Well, jury generally is a group of people, right?
Yeah, but in this case would be fair.
It would be fair. There are studies in the States. It's purposely looked at 200 groups of juries and asked judges, are you fair? Okay. It turns out the answer was no. The reason is that when they hear two sides of the story, the parties or their lawyers explain two sides of the story, they have already formed a certain opinion after they hear the case. And this is how they write the judgment or the awards. So when I say fairness, you have to act fairly. Namely, even a judge, they try to act fairly. That means usually what they say is reasonable opportunity for parties to question the other side. So this is why in our court system, you have evidence presented, then you have cross-examination, and then you have re-examinations. That is a process that gives parties felt that they are being treated fairly. Same thing in mediations. Okay, as a mediator, I have to give parties enough time, reasonable time, to respond in order to act fairly. Okay, so quite often it turns out that party thinks the person is fair or not is seen to be fair, or seems to be fair. You believe that he's fair, then you are fair. Okay? So, fairness. So we try to be a gatekeeper, okay? And try to make the impossible come true, because I had cases that I remember the party, one side of the party, he said it 5 times to me, this is my last offer. So is there really any last offer? Okay. Every time I asked him, what's your bottom line? He said, this is my last offer, this is my last offer. So I went to the other side, and the other side I gave another offer, then I come back to him, I said, what's your last offer? Okay, 5 times. So in reality, there's no final offer as far as my dictionary is concerned, because this wasn't the real case. And when I study mediation, I believe there's a last offer. Okay, they said back now, right now, is that the worst scenario, best scenario. Okay, these are theories. Okay, you probably read it in the library. But in reality, when it comes to a settlement, if parties are willing to settle, okay, there's no last offer. Okay, and quite often in real case, I find this from if the dispute is $2 million, from $2 million to 1.5 million, that's easy. Okay, it's the last $500,000 that is the trouble. Okay, people just don't want to settle on the last breaking point, and that takes up most of the time. Okay, but there's still no last offer. Okay, emotions. Well, I talk about it. People go to court, go to disputes. It's because that they're emotional, because I don't like you. I worked with you for 2 years already, and I still don't like you. That's why I want to sue you. I want you to bankrupt. Okay, I want your last dollars. Okay, I will fight with you to death. Okay, that's how people behave. Okay, so you have to accept that. Okay, and even in construction cases, you hear people swearing with each other and all that. Okay. Enough. let's start something else. Okay. So you have to control that process. Communications. People will say that I don't want to talk to him anymore. Okay. That's the last sentence I'm going to talk to him. But it's up to the mediator to encourage the parties. This is why Practice Directions 31 want people to go to mediation. But that doesn't mean that you have to settle. But it's up to the mediator to make sure that the parties keep talking to each other. Because when they keep talking to each other, they will settle. Okay? So you have to promote communications. When people say, I don't want to talk to them anymore, then on what conditions that you're willing to talk to them again? Okay? So you keep the dialogue going. Okay? It's very important. Oh, on the emotions, actually, I, as a mediator, I have my own emotions as well. Okay, just like judges. Okay, when you challenge the judge too often, he doesn't like it. Okay, he has already made the judgment on you already. Okay, so if it happens to be a traffic accident, remember this. Okay, don't challenge the judge too often. Okay, what I find is that the mediators also have emotions during the mediation process. So it's important that how you present your emotions. Okay, you can still express your views. I don't think I like this. Okay, but I think for your own good, this is the way it might be done. So it's how you phrase. Okay, this is what we call in mediation skills. I'll touch on mediation skills later. That this is what we call reframing. you will try to reframe certain sentences from what you hear. Agents of realities, okay? If you have a settlement agreement and if it's not being enforceable, then what's the point of having a settlement? Okay, you want the settlement agreement to be able to enforce. So you have to do reality check. You know, I'm going to pay you $2 million, but I don't even have $20,000. How am I going to pay you $2 million? Okay, I can say I'm going to pay you $2 million. In reality, I don't have that kind of money. Okay, so it's up to the mediator to make sure that the agreement is realistically carried out in future. And as a matter of fact, so far I haven't heard of one single case in mediation that parties didn't live up to their obligations. Okay. And if parties don't live up to their obligations, you can still take the settlement agreement to court and enforceable by contracts. Okay, trust is very important. In the beginning of the mediations, you have what I call the 5 minutes golden rule. I never met a person in my life, okay? I never met you before, okay? I have to earn your trust in 5 minutes. The first 5 minutes, how are you going to earn the trust in 5 minutes? That's a skill, okay? And it's important, okay? It's the first time I met Becky today. Okay, and I think we established certain reports already. Okay, and it's important that you gain trust. Okay, that applies to your daily life. That's applied to mediations. You have to act impartially. Act impartially. Not necessarily you are totally impartial. Okay, reliable. No personal view. Okay, what I talk about today is not my personal view. Okay. But I do add in some personal view that without you knowing it, right? There are guidelines and ground rules, like, for example, when they start, you establish certain rules. Is that, for example, please turn off your cell phone, and just so that you come to the lecture, please turn off your cell phone, okay, or put it in silent mode, okay, things like that. Don't yell at each other, okay. When the other side talks, give the other side opportunity to talk, you will have your opportunities. These are basic ground rules, okay? Confidentiality is important because it's very easy to lose trust when you don't have confidence, okay? And you have to establish respect, okay? People tend to respect you as a mediator. They believe that you can help them to solve the problem. Okay. Communication skills, interpersonal. Okay. Okay. Cooperative decision-making. So as I said, mediation is parties driven. It's not decided by the mediators. It's how help parties how to come to the decision making. And why I put physical, emotional, and procedural is procedural is there are certain procedure that you have to follow before decision making can be achieved. And physical is actually you have to have a settlement agreement. And if parties' emotions are in questions, then quite often it's going to be very difficult for them to come into a settlement. You have to analyze the conflicts or disputes, enough exchange of information, and usually through the exchange of information, you can achieve common grounds. There are always common grounds in any disputes. Okay, if there are disputes between two students in the same class, the two of you still have to see each other. That's common ground. You still have to study at the university. You still have to face each other. Okay, these are common grounds. Okay, both of you may want to settle the disputes. Okay, and an example in workplace as well. You're still going to see your boss, regardless you like it or not, unless you quit. Okay, that's your only options. Okay, but maybe that's the last option that you want to do. Okay, So through the exchange of information, you will discover what we call a hidden agenda. Okay, people have hidden agendas. You argue about something for another purpose. Okay, I could be a classic example that I gave is that when and my daughter argued with my son. Okay, they are fighting over an apple. Okay, then as parents, easy, cut it in half, each had half. Okay, that seems to settle the dispute. But both of them still crying, so that I'm in trouble. What's the trouble? Why I'm in trouble? Can anybody tell me? Why I'm in trouble? Yeah, you.
Is that real apple or
They don't want half. They don't want half. They want the whole apple.
they may want
Well, they may want a whole apple. They may want half. They don't want half. That may not be a real apple. Okay. No, I think it's a real apple.
So one of them wants, the other does not have. Wants the other not to have it. Then
More or less. Okay. So a judge will probably cut it in half, or 1/3 you and 2/3 you. Okay, that's a judge or an arbitrator based on the evidence. It turns out that my daughter may want the skin to do her kindergarten's whatever projects, okay, and the son may want to eat the apple, right? That's also a possibility. Through mediations, you can find out, through exchange of information, you can find out what they really want. This is why I said earlier, you do have hidden agenda in disagreement. Disagreement, you call it conflicts or disputes. Okay. So just like a contractor, he wants to get paid, but he doesn't want to argue about extension of time or variation or whatever reason, or the final accounts. The only thing they want is to get paid. So that's the hidden agenda. That's just another example. Oh, parties' needs. It's all, you have to discover what the party really needs. Okay. I had one case that is a commercial dispute. The dispute was $2 million. If I were the arbitrator, I probably would award one side $1.8 million. But at the end of the day, the other side accepted $400,000. I was so surprised myself. But it is a mediation, so it's not up to me to determine the rights and wrong of why people are willing to settle. It turns out that, the agreement was signed with $400,000. Okay, after a couple of months, I saw this contractor, and I asked him why you are willing to settle at $400,000. Obviously, you know as well as I do. He said you probably get over $1 million anyway. Okay, why you are willing to do this? So he told me is that I want to settle this once and for all. I don't want to drag on the case for another 2 years in court. Instead of spending 2 years, managerial time in 2 years, he probably gets some more money. He doesn't think it's worth it. So that's a commercial decision. It's not a totally a right and wrong situation. But in court, you don't have that process that allow you to settle at $400,000 because it's not parties' determinations. Okay? So that's why parties' needs is important. Clarifying the issues, as I said, I have 2 pages, and that was the example I gave. Constructive communications, okay. Agreement on facts. Oops. Too quickly. Facilitative negotiation, problem solving. So the mediation process is focused on interest based, not on positioning. I talk about positioning when you're in a legal process, okay, in arbitrations, okay. But here we look at the interests of the parties, the needs of the parties. That determines the outcome of the mediations. When people get too aggressive or emotional, we try to separate the people. Oh, jeez. I need to go faster. Okay. I'm not going to go through this. Okay. The process. We normally have opening statements which allows parties to present, it allows the mediator to present the case, to tell the parties that I have no conflict of interest, I will keep confidentialities. Then the party statements is that parties will have an opportunity to present the case, each side. Then the mediators try to summarize. The reason, again, is that when people are talking, they don't listen. Okay, this is an opportunity for parties to listen to their wishes, because in the party statements they will tell their wishes, and now it's for parties to listen to the wishes, because sometimes wishes are not realistic. When they hear the wishes, they say, no, this is not the case. Okay, they will clarify. Okay. Then we set the agenda. What are the disputes that need to be settled? Then, as I said, the first joint session is that the two of them will express their position, really. I allow them to declare the position, because you will not solve anything in the first joint sessions. Then I might separate them into individually, talk individually. Again, confidentiality is very important. And there could be a series of separate meetings or joint meetings, depends on the situations. And hopefully there's an agreement. There's an 80% chance that you get an agreement, and that settles the whole disputes. I'll just mention that what is covered in opening, and I don't mention the rest. One of the important things I will highlight is termination. Parties can terminate anytime if they don't like the process. It's voluntary, so you come here to try to settle. It's voluntary, okay? And it is without prejudice. That means that none of the information during the process will be disclosed after the mediation sessions. Again, in notes taking, that is confidentiality as well. Skills. Okay. Different skills that's being used in mediations. When parties talk to each other, you have common grounds and mutual interests. Okay. This is the area that we're focused on, because these are the areas with no disputes, and we will use these common grounds for future. When we try to resolve disputes, we use common grounds to help parties to settle. The mediators is actually only a communicators between the parties, because parties cannot negotiate with each other. They fail the negotiation. That means they can't talk to each other in a reasonable and sensible manner. They need a third party to be the interactions between them. Well, 6 elements of communication, you might read it in typical communication books. You need to be communicators. There are objectives. Okay, what is the media? Okay, it can be in writing. It could be verbal. And actually, when I talk about verbal there are verbal and non-verbal communication as well. Namely, what I said, you hear. My gesture like this versus this, I'm sure that you felt differently. Okay, I'm on a defensive mode when I'm doing this. When you're sitting like that, you want to protect yourself within your own little sphere. Okay, when he's sitting like this, he's more leaning forward, listening better. Okay, so there's a lot of body language. It turns out that 55%. I think I have it in one of the slides. Yes. No. Verbal communications, okay, is only comprised of 38%. 38%. Okay. You probably remember a person when after you walk out the door. You probably don't know me anymore, but you remember my gesture, my non-verbal activities, more than the verbal activities. Okay. It turns out the non-verbal comprise of 55%. Okay, and the content, all these PowerPoints is only 7%. It's only 7%. Okay. Just like in our electrical, you remember long hair, but you don't remember what he said. You only remember his face or his gesture in electrical. Okay. So there are different media, okay, and different messages, and naturally, audience and the environment is different. If you are in an office or in a classroom like this, or in a coffee shop, it might be very different. In workplace, the audience could be your supervisor versus the staff. Okay, it could be very different. Okay, verbal, non-verbal. Simple language, trust. Okay. Okay, I'm not going to cover this because I am running out of time. I hope to leave 20 minutes for you to ask questions. Here, first of all, both parties have to understand the dispute. The paraphrasing is important, and then I want to make sure that is the situation, and you have to summarize. Every time, regardless of joint session or separate caucus, separate sessions, at the end of the sessions, the mediators need to summarize what you hear and confirm what he said, so that people understand what they said is what they actually meant. Questionings, active listening is very important. In the Chinese word, ting, okay, you use your ear to listen. You use your eyes. You use your eyes to listen. You use your heart to listen. So, actually, it's not only the ear that's listening, but your eyes as well. Facial expressions, okay, eye contact. I look you in the, when I ask you a question, I look you in the eyes, you know that I'm talking to you, right? Leaning forward. If I walk into the room, if I talk in the middle of the class, you probably felt differently, right? Compared to I'm talking over there, isn't it? At least you won't be falling asleep because I'm so close to you, right? I'm using open gesture, posture, open posture. I'm talking to you, right? I'm not talking to you. That's the difference, okay? Reframing. Sometimes parties speak violently, okay? I would say violently and emotionally. So it's up to the mediator to readdress the situation. I don't want to do this. So the mediators may want to reframe it in such a way saying that I don't think I have time to do this. I might do it differently. So it softens the tone of the statements, okay? There are different techniques, okay, and lead the parties into the right directions and hopefully come into agreement. I don't think I can finish, okay? So reframing, changing the meanings, okay? I'm just going through it very quickly. There are different scales, okay? Acceptance, I won't have time to go into the scales because this this actually the facilitative skills is very good, even in your daily life. You know, a lot of my students who took the mediation course, they came back to me and say that they could use it in their daily life, not only in a specific area. And they may never be a mediators themselves, okay? So I don't think I have time for all this. Last gap, we talked about last gap. There are different techniques of closing last gap. It was difficult to close last gap normally, okay? You can split the difference, you flip a coin different ways, okay? Or you split the issues into smaller packages to settle, okay? There are techniques of doing that. Or you, there was an occasion that the two brothers was so unhappy about the settlement, so I break up the sessions and said, well, why don't we come back tomorrow morning at 9 o'clock and we talk about it again. And the next morning they came back and they settled, okay? There are different techniques that we could use. Option generation, very important. Don't think about the disagreement itself, because the disagreement itself may have hidden agenda. You have to think of solution beyond beyond the dispute itself. Okay, this is one of the last slides. Difference between arbitration and mediation. Arbitration, again, neutral, impartial third party, but it's subject to procedural law, so you are sworn under oath when you do arbitrations. Okay, it's based on law, facts, and precedent case. So what similar cases previously will be used, but in mediation, we don't get involved into this. Again, it is adversary. One thing I have to highlight in arbitration is versus litigation. So in litigation, if you don't like it, you have the Court of Appeal and the Supreme Court normally, okay, for appeal. But in arbitration, no, because arbitration is a process that you agree at the time of signing your contract. So before any dispute occur, you agree on this process. So at the end of the arbitration process, you have an arbitral award. The award is very difficult to appeal. You can go to court and try to challenge, and the only way is that if the arbitrators have a conflict of interest, you can challenge. Otherwise, the court will support the arbitration process, especially in Hong Kong. Okay, so very limited appeal process. Okay, it is enforceable internationally because any arbitral award can be enforced in about 200 countries around the world. That's the New York Convention because China has signed the New York Convention. Okay. So decisions is by the arbitrators and or arbitrators. Sometimes you have 3 arbitrators. And the good thing about arbitration is that you can select a specialist in your area of interest. Last, mediation is an art, and you can learn it through practice. Just like you are playing chess. It's easy to teach you how to play chess. It's difficult to play good chess. You are a good chess player. Exposure through interaction with people, learn from others, sharing information, be a better communicators. I think you need to have hearts to do mediation. Thank you.
Thank you, Professor Leung. It is a very interesting topic to me. It's very new topics. And so it's the Q&A section. Anyone have specific questions to Professor Leung? Yes?
I noticed on one of your slides, one of your techniques you mentioned is one of the techniques was shaming the client.
Well, shaving, huh?
Shaming.
Oh, shaming. Oh. How it's done is that this is on the final closing the gap. Okay. If you don't agree to his proposal, do you think that you could be discredited in your own company? You could be the person in charge. You still have to report back to the company. The company may want you to settle, and because of the last gap, you can't you may not be able to go back to the company. That's called shaming the other person. Because for all employees, you have answerability to your boss, right? So because if your boss wants to settle this, okay, and you're not able to achieve that, you think that you can be answerable to your boss. So that's a form of shaming the other side. Okay. So make him feel bad about not to achieve the settlement. Okay. That's what I meant there. Any questions?
Okay, yeah.
Thank you very much for the lecture, sir. I have a few questions here. Number one is looking at maybe I did not listen very well when they started the introduction. I want to know how you are able to acquire all this knowledge about this mediation, because I could observe there was little or no references from everything I saw during the presentation. So I was thinking maybe many of them are from your own inspiration or from your own work. That's number one. Number two is that, sir, if I have issues, I have conflict or dispute with a particular person, and we need a mediator, who among us has the right to really bring the mediator? Because I'm thinking, is it possible for both of us who have dispute to agree as a particular person to be the mediator, or the mediator will just walk in? And could there be two mediators? If I bring my own mediator, he brought his own mediator, and two mediators interfering in the whole issue. Another thing is that, do we have charges?
Let's answer two first, and then you have your chance. First of all, I think some of these PowerPoints, some of the issues you can learn, basically. But some of these views are my views as well, like selection of mediators, what you need on the mediators. Because what I found is important that you find the right mediators, because most of you will be parties in the disputes rather than acting as a mediators. But it's important what you need to look at when you find the mediators. So that was the objective. And I'm sure Maggie can post up the PowerPoint if you want to read it more. Okay. How one can achieve all that is that, well, some is through your life experience. Second is that we do have mediation training course on skill sets and what some of the items I talk about. Okay, like how do you do reframing, how do you closing the gap, these techniques. Okay. The second question is on bringing your own mediators. Okay, there is something called co-mediations. Like for example, we talk about hospital disputes. One mediator may be a doctor, the other is a mediator. Okay, so the mediators will be more focused on the communication between the two parties, the dialogues, and try to come up with a solution. But the doctor mediators may be providing some very technical advice to the disputes. Okay, go back to the example that I gave you earlier on the trading case. I don't know anything about that electrical products. I didn't need an electrical engineer sitting beside me, because what I did was that I used a joint session to get both of the engineers to sit down and come up with a technical solution. And I helped them to come up with a technical solution so that could be presented back to the mediation itself. Okay, so there are techniques that we can use, not necessarily getting an expert mediator doing co-mediations. I personally sometimes don't quite believe in co-mediation as well, because when you have two mediators, who is going to make decisions at the end of the day? That could be a conflict on its own. Okay, but I agree on very complex cases, you might need 2 or 3 mediators to help. Like it could be a nuclear plant dispute or international disputes. Maybe you need that. You need that because you need both sides to running around to more focus on one side. Okay, so there are situations that I think it warrants 2 mediators. But, okay, on the selection of mediators, yes, both parties have to agree on the common mediators. And actually, that's one of the biggest problems, is that when you select me as a mediator, the other side automatically rejects, right? I have that situation to me. But as I said, why the case that I earlier referred to is that I was acting for an advisor to a party. Remember? I was selected as the mediator. That the other side objected. And interestingly enough, is that the party that select me, they still want me to advise them. So I said, okay, I'll be your advisor on your case, but I won't be helping the other side. So he hired me as an advisor to his mediation. Okay, I just changed the agreement into mediator's agreement into advisor agreement. So to me, I'm still getting the same pay. So there are parties that needs advice in the mediation as well. Okay, because it was a complex case as well. I hope that answers your 2 questions.
Okay.
Anybody else?
Any other? Let's chance. Give the chance for others first, and then you have your
You have your third question.
And other questions first? Yes.
As you say before, listening is really important as a mediator. But when will you usually give your advice, your opinion when you are in the mediation?
First of all, you don't give advice in your mediation. There are techniques that help you to lead the parties. Because in facilitative mediation, we cannot give advice. But in evaluative mediation, we do. Okay? But as I said, in Hong Kong, we promote facilitative mediations. So what I can do is that, give you an example, is that in the events that you don't settle your case, do you know how much legal costs you're going to pay? Oh, I have no idea. So maybe will you consult your lawyer to give you an indication on the legal costs involved? So am I giving leading questions? So that is acceptable in facilitated mediations. Namely, I did not tell you what the legal cost is going to be. Right? You are still seeking the answer from your own advisor. But I just highlight to you that, do you know how much is it? That gives you an action that you need to carry. Okay? That's an example. Okay? So in mediation, we do not give advice or guidance, but that doesn't mean that we don't steer the whole mediation into certain directions. Okay? So it's a matter of how you do the questioning. We didn't have time to go into the questioning techniques. There are open questions, closed questions, okay, that you can ask. In mediation, we tend to use open questions so that you could have an opportunity to express yourself. Okay.
Okay. Any other questions? Yes.
All the stuff that you talked about, they generally help people when they are out of graduate school, right? Like in the actual workplace. So can you talk about something about that?
I don't agree with your first statement, because we do have peer mediation in primary school and high school.
But I mean,
So it helps people.
in universities, for example, we don't have conflicts where there is money involved most of the time. It's generally
You argue with other students?
no, it's generally with professors, right?
You're very good. You don't argue with other students.
So in those kind of cases, or maybe in authorship or stuff like that. So like there, the nature of the dispute is different. So like, what kind of mediation can be involved in that?
I think transformative mediation can be used. I think one of the slides does show transformative schools. The reason is that you're not on equal basis with a professor, for example. If you have this dispute with your professor. You're not on an equal basis. So transformative mediation will do empowerment. That means that the mediators will give, for example, more opportunity for the students to express their views and less to the professor. So that brings the power equalities into a more fair basis. Okay, but you still can use facilitated mediation in that case. It's just that, for example, even just little things. I was involved in one mediations that the two sides were arguing with each other, and one side suddenly picked up the pots of water, okay, and pour the water to the other side, to me and to him. He just wants some water, actually. But as a matter of manner and courtesy, he poured the other side first, and then to me, and then to himself. But the other side was so pleased that, hey, he's being nice to me, okay? So just little things like that, it does help within the mediations, okay? The initiative. I had another mediations that the parties, in one of the caucus, he said to me, he said, Raymond, I'm so happy today. I said, why are you so happy? You haven't even settled the case. Why are you so happy? He said, for 8 years, this case lasted for 9 years. It was settled, it was in court 9 years. It's a trademark disputes. Okay, he's using somebody else. The trademark was being taken by one of the parties. I'm so happy after 8 years of arguments, okay, back and forth, letters back and forth. I'm so happy today. I said, why are you so happy? You haven't even we haven't even started settling the case. Okay? I'm so happy I see him today, and I can tell him face to face that you're infringing on my copyrights. Just like that. That's how people react. These are real cases. Okay? He's so frustrated because he has spent millions of dollars, like over $2 million, just on writing to each other. Little things. Just the presence of the other side, he's happy already. I have another case. I do all strange cases. Okay, so that's why I have another case. Is that this person is suing a newspaper company. So everybody is shaken. It's so important, you know, to the enterprise. It's very important. Okay. They went to High Court. The High Court referred the case to me, and that case was settled in half a day. The reason is that the person suing the newspaper, actually what he wants is he wants to see the boss of the newspaper so that he can complain about his paper. And he spent, he literally take this case to the High Court. That's how people behave. Okay, after in the mediations, because the boss of the newspaper company was there, okay, and he was there, okay, he was willing to settle right away. And even the lawyer representing the newspaper company was so surprised. How come they settle so quickly? Okay, so I'm just giving you a different scenario.
So, all right, I think we need to end this session. If you have time, please stay and have other questions with Professor Lam. Let's give big thanks to Professor Lam. So this session will end. So you can leave. If you have time, please haven't finished the sandwich and biscuits. And any questions, more questions to Professor Lam, please come.